Welcome to the Center for Comparative Immigration Studies at UC San Diego. Today we are hearing from a panel of legal scholars and practitioners on the state of immigrants and refugees' rights in the United States in the aftermath of the 9/11 terrorist attacks. Not since 1996, when Congress was passing laws that sharply restricted the rights of legal immigrants already living in this country, have immigrants' rights been so under fire as they have been in the last 2 years. In the name of fighting terrorism, numerous actions have been taken by Congress, the executive branch, and the courts that impinge on the rights of immigrants and asylum seekers. A very partial inventory of these measures would include the USA Patriot Act, which, among other things, made it possible to detain immigrants and foreign visitors indefinitely without hearings or filing of charges. The Enhanced Border Security Act, which mandates the use of biometric identifiers for visas, as well as tougher scrutiny of visa applications, especially from young men originating in Arab countries, and tighter controls on visas sought by private companies for their foreign employees. There have also been some important changes in the way that temporary visa holders are monitored once they enter the United States, including closer tracking of foreign students in our colleges and universities. And the federal government has begun to enforce a 50-year-old law that requires non-citizens to report any change of address within 10 days. By March of this year, more than 1.2 million unprocessed address change forms had piled up in federal warehouses in response to that change. The Justice Department has set up a task force on foreign terrorist tracking, charged with locating and interviewing more than 8,000 Middle Eastern or Muslim men between the ages of 18 and 33 who are in the U.S. on short-term visas. Congress also mandated the creation of an entry-exit registration system, the most controversial feature of which was the so-called spatial registration of nationals of specific Middle Eastern or predominantly Muslim countries who are living in the United States. The countries whose nationals were targeted for spatial registration were grouped into 4 categories, and they were assigned different deadlines for registering. All immigrants from those countries found to be out of status, out of legal status, for whatever reason, were detained immediately, even though they presented themselves voluntarily for registration. The largest number of immigrants detained in that way were in Los Angeles, which prompted strong protests from Iranian Americans and other affected communities. Other policies adopted by the Justice Department have affected the rights of asylum seekers. For example, under Operation Liberty Shield, asylum seekers from Middle Eastern and Muslim countries are to be detained automatically while their applications for asylum are being processed. Federal authorities have also carried out several special workplace enforcement actions aimed at apprehending undocumented immigrants who were working in sensitive places like airports. Operation Tarmac rounded up more than 800 cleaning women, catering truck drivers, and baggage handlers at airports around the country. netting no suspected terrorists. Operation Game Day was carried out in San Diego in the name of reducing the risk of a terrorist act during the Super Bowl game. It targeted immigrant workers at Qualcomm Stadium and companies that provided services to the Super Bowl. And like Operation Tarmac, it swept up only people who had nothing to do with terrorism. A variety of other policy changes and actions have been proposed, but not yet enacted. They include barring the entry of all immigrants and tourists from Muslim countries, an approach that was endorsed by nearly 80% of the respondents in a national survey. Reducing the level of permanent immigration, permanent legal immigration from all countries, ostensibly to reduce the workload of immigration authorities and deny cover to terrorists. Also, a legislative proposal that would mandate closer cooperation between the Border Patrol and state and local police departments. A law that would bar police and banks from accepting cards issued to undocumented immigrants by Mexican consulates as proof of identity. And also measures to keep driver's licenses out of the hands of illegal immigrants. It's arguable whether any of these immigration control measures could have bought us improved security from terrorism. In fact, some have argued that measures like the comprehensive alien registration program and the enforcement of change of address laws could be counterproductive in the war against terrorism by flooding the Department of Homeland Security with so much information that it can't be processed in a timely manner, and diverting resources from efforts to find those needle-in-the-haystack terrorists. In other words, we may just be enlarging the haystack. What is unarguable is that taken together, all of these measures have caused a significant erosion of legal protections for immigrants, foreign visitors, and asylum seekers of all backgrounds. Profiling on the basis of nationality and religion has been legitimated as a tool of anti-terrorism in federal policy as well as public opinion.
To give you a sense of what we're experiencing on a daily basis, I'd like to take you back to pre-September 11th days. Even then, the Immigration and Naturalization Service was a dysfunctional agency. They were known for loss of documents, huge backlogs, inadequate resources, lack of training. This is nothing new. Calls for restructuring of the agency abounded even pre-September 11th. Then, of course, September 11th happened, and there was a new concentration and urgency focus on the Immigration Service. But I think the true defining point for the former Immigration Service was not September 11th. It was really March of 2002 when an immigration adjudications officer issued an extension of visa status, not only to a terrorist, but to a deceased terrorist. I think that drew media attention and a heat and focus on INS that they had not experienced prior to that time. Previously, who suffered from INS's lack of efficiency? Foreign nationals who don't vote. With the exception of foreign nationals who are working for U.S. companies where they have a lobbying interest, most of these individuals simply went without their rights being litigated, without their rights being acknowledged in the media. Many agencies, such as the agency that Claudia works for, Legal Aid, Catholic Charities, there are many agencies which do an amazing job at pro bono work and representing these types of individuals. But for the most part, where there was not a national security concern, where there was not a dollar bottom line objective, the damage done to the civil liberties, human rights of these individuals was greatly ignored. Turning to the new structure now under Department of Homeland Security. As most of you probably know, the former Immigration Service is no more. It was dismantled in March of this year in place of the Department of Homeland Security, which is an umbrella agency which I believe the number is 75 federal agencies now report directly or indirectly to the Department of Homeland Security. The immigration functions themselves have been split up into three. One with the U.S. Citizenship and Immigration Service. They do the adjudications, the permanent residence applications, both family-based and employment-based, work authorization documents, that type of thing, naturalization. And then the enforcement function was then further separated into two under the Under Secretary of Border and Transportation Security. Asa Hutchinson was appointed to that position. And under him there are two agencies, one called Customs and Border Customs and Border Protection. And they basically deal with enforcement at the borders, all the seaports, airports, land border ports of entry. The CBP is comprised of the Border Patrol, Customs, and the Agricultural Quarantine Program. Now, this has inherent difficulties, which I will explain in more detail. But just to give you an idea, so with the synthesis of these various functions under this one agency, you have individuals who were previously charged with and trained to inspect for contraband avocados, who are now determining someone's visa status, whether they have committed any act which renders them inadmissible to the United States, and there are serious, egregious problems with this process. The other enforcement agency, which I mentioned, I guess they got the hip and cool acronym of ICE. They are the Immigration and Customs Enforcement. They're charged with interior enforcement in the United States. They do interior investigations, intelligence gathering, detention, deportation, and they had the dubious honor of running the special registration program, which Dr. Cornelius alluded to and that I will go into in some additional detail. To give you, I attended a Forum Fronterizo event in June that San Diego Dialogue had sponsored. And Asa Hutchinson, who is the Undersecretary of the Border and Transportation Security Directorate under Homeland Security, was the keynote speaker at that event. And granted, his job is to sing the praises of the new restructuring and how everything is going to be just fine. And he said specifically that the new restructuring has created a direct line of command. From my position as a practitioner, nothing could be further from the truth. And this is not gratuitous government bashing. Another presentation I did fairly recently, someone felt that I was a bit too critical of the U.S. government and the Immigration Service. And I do not say what I say lightly. There are many individuals who are caring, compassionate, capable, who work for the Immigration Service and who care about their jobs. They have a monumental task. The San Ysidro Port of Entry is the busiest land border port of entry in the world. So I'm not belittling the task they have at hand. However, having said that, I'm very conscious and careful with my remarks that there are reasons to be gravely concerned. Lack of training combined with the focus on enforcement is a very dangerous combination. And the people most likely to suffer from these inefficiencies are those individuals initially subjected to special registration. Predominantly Muslim males, or I should say males from predominantly Muslim countries. There's an unofficial list of individuals who are targeted. The State Department has refused to indicate exactly which countries are on that list, but between immigration practitioners, the Immigration Lawyers Association, of course, we've put together by hit or miss the bulk of the nationalities. They are not all Arab countries. They include Pakistan, Indonesia, the list that Dr. Cornelius had indicated previously. To give you some examples of what I'm talking about when I talk about the inefficiencies of the system, there was an article in The Nation back in December of 2002, so almost a year old at this point, citing a General Accounting Office report that indicated that the Immigration Service in the previous fiscal year was unable to account for 2 million documents. 2 million documents. 200,000 of them at that time change of address cards. Dr. Cornelius mentioned the enforcement of a 50-year-old law regarding the mandate that a non-citizen change their address with the Immigration Service within 10 days. That law has been on the books since the Immigration Act of 1952 and was not enforced until very recently. And in fact, the first attempt to enforce that provision was thrown out by a circuit court judge because he felt that the Immigration Service had not given sufficient notice to people that this provision would now be enforced and complied with. And Dr. Cornelius mentioned 1.2 million change of address cards have not been entered into the database. So here we have a system where we are requesting that individuals comply with very strict provisions of the law, and in fact the penalties are serious. The failure to file the change of address within 10 days on the books is both a misdemeanor and separately a grounds for deportation from the United States. Now, ordinarily, and this applies to green card holders as well. When we say non-citizen, that means non-U.S. citizen visitors, people here on temporary work authorization, and lawful permanent residents, those holding a green card. And again, who is going to suffer the most? Those individuals who were called in for special registration. I should say that the government's position is that registration of all foreign nationals, non-citizens in the United States is going to be implemented on a broader scale. In fact, that was mandated by the Homeland Security Act, and there are phases of implementation. It's called the U.S. Visit Program, which I'll address in some additional detail later. So in addition to the lost documents, erroneous documents. Again, I see this every day. I see it with my clients. I had a family of Nigerian-born Canadian citizens. The father, the principal, should have been admitted to the United States in H-1B status. That's a temporary work authorization for those in specialty occupations, engineers, scientists, the like. His wife and children should have been admitted in H-4 status, which allows them to be here for as long as the principal is here, but not to work. Well, they come to me to file an extension of their case, and they give me their entry documents. They've all been admitted as Mexican citizens. I wonder how that happened. The mother was admitted for duration of status. That means that, hey, she can stay as long as she likes. There's no finite date on there. And the children were given work authorization. Now, this is the nature and severity of the problems. Now, you take someone with erroneous documents like that, who happens to be Iranian, Iraqi, Syrian, Pakistani, and they go for their check-in for special registration. What's going to happen to these individuals if we have the same level or lack thereof of training at the district immigration offices, which, again, I can attest that we do? These individuals are going to be held accountable for things which are beyond their control, and it is their civil liberties which are at issue here. Many, many individuals were detained. 82,000 men complied with the call-in registration program, which officially ended in April of this year, but the effects of that are still being felt. People are still being registered at the ports of entry. They are still asking, the Immigration Service is still requiring that these individuals comply with the registration requirements, checking in 30 to 40 days after entry, departing the United States from designated ports of departure, notifying within 10 days of change of address, employment, school, etc. Again, perhaps these things that we're asking of people are not unreasonable in terms of the security environment that we're facing today, but we have to have a system in place that can accurately note this information and apply it non-discriminatorily. To give you one more example regarding the nature of the errors that we see, in this morning's mail, I received an interview notice for a client of mine that she and her husband should appear before the immigration office. I won't name which district it is, I'll save them the embarrassment. But that they apply for an interview to complete her permanent residency process. That's a normal part of the process for someone who is adjusting their status based on marriage to a U.S. citizen. The only problem is that her husband is deceased. He died in the trade center. One could say, well, perhaps the government didn't know this, but they do, because I filed the required documents notifying them that the husband was deceased with a copy of the death certificate, a copy of the printout from the internet indicating how he had died and asking for a waiver of the joint presence requirement. So the fact that this letter was still generated indicates to me that there was no review whatsoever of this woman's file. And I really hope, just for her sensitivities, that a copy of the letter did not go to her directly, because at this point I'm going to be charged with trying to communicate with a human being at this district office to get them to revoke the letter and grant her the residency. So this is the nature of the errors that we deal with, and I know that the others can attest to this. These are not isolated incidents. To turn to the special registration, again, post-September 11th, there was public outrage, disbelief that terrorists could have committed these acts basically right under our noses. There was a fervent demand for action, protection of national security, and some even responded, I'll give them the benefit of the doubt, with visceral responses calling for roundups of individuals of certain nationalities wanting revenge. Now, we did not have roundups of that nature, but we did get what is called the special registration process. It's part of the USA Patriot Act. These are all acronyms. USA Patriot, people must stay up late at night thinking of these things. It's uniting and strengthening America by providing tools for the appropriate interception and routing of terrorists or something. I mean, somebody stayed up late to think of this. So in any case, the Patriot Act also required something called, the acronym is NSEER's National Security Exit Entry System, basically better tracking of people's entries to and departures from the United States. They did this in several phases. Some individuals were asked, based on their nationality and various profiles, to come in and register with a district office. And I think that everyone had followed to some extent the media attention as to the repercussions of those activities. There were a variety of problems inherent in the system. There were phases of the implementation. The first phase applied to citizens of Iran, Iraq, Libya, Sudan, and Syria who were entering at a port of entry, meaning coming through at a land border, airport, seaport. And that applied to both men and women. And so they were subjected to the registration. What does the registration mean? They take a digital fingerprint, they take a digital photograph. They asked, because I went with my clients for the first few times, they asked personal information, contacts in the United States, contacts in the home country, parents' information, down to their bank account numbers. All right, so they took a great deal of information from these individuals. And I mentioned previously the types of ongoing compliance that these individuals are required to sustain. There were various phases thereafter, some call-in registration for certain nationalities. They added Pakistan, Saudi Arabia, Bangladesh, Indonesia, etc. in various stages. And there was also what was supposed to be a secret internal memorandum that was leaked to the press and then found its way to the internet, so I don't feel uncomfortable sharing it with you. It's pretty much public knowledge regarding individuals who, in the service's discretion, can be subjected to special registration at the ports of entry. And I remind you that the registration at the ports of entry is ongoing. It was only the call-in registration which ceased after it had reached a certain number of countries. And that secret memorandum allows the Immigration Service to subject individuals to special registration if their trip lacked credibility. They didn't have a good explanation of where they went and why. If they had previously overstayed a U.S. visa, all right, I'll give them that. They meet certain characterizations established by current intelligence updates and advisories. Person's behavior, demeanor, or answers indicate that they should be monitored. So if you have someone who's a little bit nervous and you have an immigration officer, and again, this comes back to the training issue, who is then determining whether or not this person should be subjected to a special registration. Again, I think that's a matter of concern. Back to the issue with the accuracy of the information. The Justice Department and now Department of Homeland Security took an immense amount of information from 82,000 males who reported for call-in registration. I can tell you as a practitioner, when I'm filing extensions of status, changes of status, etc., the whole gamut of what we do, I get requests for additional evidence back from INS, requests stating, did this person, or asking, did this person register pursuant to call-in registration or at a port of entry, and can you provide proof? Wait a minute. You're asking me? This is the agency which took this information. An enormous amount of information. You tell me if they're registered. Very serious problems with this. Problems at the ports. Every time people travel, they turn in the document which shows their status. It's called an I94 card. When they come back, they get a new one. For a long time, the government was writing the special registration number on the I94 card, which is turned into the airline when the individual leaves the United States. So they come back, they now have no proof of their registration. So I was telling people, make copies, send it to me, I have it in the file, etc. But again, theoretically, this shouldn't be necessary. The government's own database should have this information. And that was one of the critical issues or pitfalls which many critics have said led to September 11th, is the failure to share information among agencies. Again, this is a monumental task. I don't doubt that, and I understand that the government has an immense choice getting the various databases to share information. These are the types of things that are of great concern.
I think that the consistent theme that we will hear over and over again is that the war on terrorism has become a war against all immigrants. In fact, even against immigration advocates such as myself. People wonder why we represent certain individuals, almost in the same way that criminal defense lawyers would be asked, how can you defend a criminal? Now we see immigrants through the lens of terrorism. The changes that have taken place since September 11 are overwhelming. To be quite candid, I personally cannot keep up with them. I focus on the things that I practice on a daily basis, on what is needed to defend my clients, but every single day I get 5 or 6 emails from the different organizations informing me of new changes. So no wonder we are living such difficult times. The changes, of course, are not for the benefit of immigrants, but against them. I would like to highlight a few of the areas. I think that Dr. Cornelius has already outlined them at his introduction. And the first area that I want to discuss is the denial of liberties. On April 17th of this year, Attorney General John Ashcroft overruled an appellate court and issued an alarming new precedent that people who were undocumented did not have the right to post a bond, or I should say did not have the right to a bond hearing, simply because he would send a message to other people to come to the country illegally, and as he stated, such release would serve to stimulate mass migration and threaten national security. So again, immigrants put in the place of terrorists. Gee, if we grant bond on this individual, everybody would want to come, including terrorists. Let's be careful. In most cases, before this decision came out, the immigration judge had the discretion to look at the facts of the case and to decide whether or not this person presented a flight risk, to decide, the amount of the bond. And in most cases, the individual was given a bond and was able to be released pending the duration of the proceeding. So now we have to contend with that issue. Second, the Supreme Court, very, very recently, again in April of this year, decided a precedent that is hurting all of our clients who are in the country legally. Now we're moving away from those people that have no documents, including asylum seekers who want a bond, to lawful permanent residents of this country who have been here perhaps 30 or 40 years, and who, because they committed certain violations, certain crimes, now the Supreme Court has stated they are subject to mandatory detention even if they are entitled to relief. What does this mean for many of the Mexican nationals? This is a border. The majority of the people that we deal with happen to be from Mexico. many of them lawful permanent residents. What it means for the daily practice of those of us who have to defend those immigrants is that we have to tell them that they will not be entitled to a bond, even though their case has merit, even though we may prevail ultimately in getting a remedy, in getting a waiver, so they can remain in the country. The tragic consequence of the Kim decision decided by the Supreme Court in April is that many of our clients give up. They forfeit the rights to their hearing. They forfeit the remedies that they have because they don't want to be waiting forever. It's not as if we, their lawyers, can tell them it will be a matter of 3 months. It will be a matter of 6 months. No, it could take months, if not years, before the case can be resolved. So here we have long-time permanent residents who are now subject to mandatory detention. What is interesting is what the Supreme Court said, and of course this is not new. The Supreme Court has never been that sympathetic to immigrants. But it said that mandatory detention, the denial of bond to lawful permanent residents, does not violate substantive due process. In other words, it was not unconstitutional because Congress is authorized to make rules regarding non-citizens that will be unacceptable if applied to U.S. citizens. Let's be very clear, lawful permanent residents do not have the same rights as U.S. citizens. And this is very interesting because initially when the Kim decision was decided by the Federal District Court, the Federal District Court ruled that lawful permanent residents had the right to a bond, had the right to have the judge decide if they presented a flight risk. After all, they had deep roots in the community. They had families, they had U.S. citizens, a home, employment. They were members of our community, not newcomers. And yet, they remain in custody. The Supreme Court reversed the Federal District Court and the Ninth Circuit Court of Appeals when it issued that decision. And even though Kim, the subject of this decision, had nothing to do with terrorism or post-9/11 issues, it provides an indication of how the Supreme Court may rule in the future on similar cases. This is just the beginning. Also mentioned by Dr. Cornelius was Operation Liberty Shield, where John Ashcroft issued a mandate that all asylum seekers, those who are at the ports, either the airports or the ports or the land ports, who were requesting asylum, would not be entitled to a bond and would be, again, subject to mandatory detention. So do you see what we hear again? Whether they're asylum seekers, whether there are people with no documents, whether there are lawful permanent residents, it's the same thing, subject to mandatory detention. And John Ashcroft's rationale was that they had to remain detained for the duration of the processing of their application, which again, it could be months or years. If they came from nations where Al-Qaeda, if they came from nations where Al-Qaeda sympathizers or other terrorist groups have operated. So again, asylum seekers placed in the same situation as terrorists. It is ironic, the people that were fleeing persecution, the actions by the government because of who they are, what they believe in, or what they represent, were coming to the United States to seek safe haven. In an ironic twist of fate, those same individuals will be further victimized by the U.S. government, who would deny them bond in those cases. There was such strong criticism by Immigrants Rights Group, immigration lawyers, academics, the international community, that basically told Mr. Ashcroft, what you are doing violates not only U.S. law, but international standards. Stop it. And it worked. This is one of the few instances where we were successful in actually abolishing this terrible policy of victimizing victims. Now, turning to refugees, delays in security checks, the fear of terrorism, has also severely debilitated the U.S. resettlement program. What does this mean? Every year, Congress, in conjunction with the President, would set a number of refugees that would be allowed to come to the United States to resettle. The numbers fluctuate every year, but traditionally they have been around 90,000. We allow 90,000 refugees to come from overseas to resettle in the United States. In 2002, the number was reduced to 70,000. That's not bad enough. Of those 70,000, only 28,000 were allowed to come to the United States to resettle. About 1/3 of the ceiling of 70,000. Why? Because of security checks, because of fear of terrorism. Those refugees that we had already selected to come to the United States did not make it. Unfortunately, what happened in 2002 has now become the standard, the precedent, because now for 2003, the number of refugees that have come in the fiscal year ended for the Immigration Service ends September the 30th is about 26,000. Again, about 1/3. What is happening to those refugees? Who's going to take them? Will they ever be allowed to come in? We don't know. The refugee program has always been a source of pride for our country and our strong commitment to freedom around the world. But this wonderful program has become another casualty of the war against terrorism.
I have been asked to talk about border and interior control in the context of 9/11. And what we have is an immigration control policy that rests almost exclusively on beefing up the Border Patrol, and a policy which kills hundreds of migrants a year as a result, at least 2,700 at last count since 1995. It's been almost 10 years and more than $20 billion since we launched Operation Gatekeeper and its counterparts in Texas and Arizona. And all that we have managed to do is to push the undocumented foot traffic out of the urban areas and into ever more dangerous places, now mainly the deserts in Arizona. The aim has never been to keep migrants out entirely. After all, we have built entire industries around the cheap and throwaway labor from south of the border. Actually, Gatekeeper at all was a political strategy initially. It was designed to move the illegal crossings out of the public eye. The chaos along the first 14 miles of the border, where about 25% of those crossings were undertaken back in 1994, became the fodder for Proposition 187. And California is a vote-rich state. There was a presidential election looming, and the Clinton administration needed to get tough on illegal immigration. After 9/11, we talk about the southwest border as a national security problem. But sealing the border is just as unrealistic now as it was before then. And not just because of the sheer physical impossibility of doing so, but because where would Walmart get cut-rate cleaning crews? Consider, for example, that the former INS conducted only 300 workplace inspections in year 2002. As the U.S. Chamber of Commerce warned last year, an aggressive push to rid the country of undocumented workers would destabilize some industries. I think the Chamber overstated it when it said that if we sent them all home, the economy would stop, but you get the picture. The fact is that the border has gotten deadlier since 9/11. especially because at the ports of entry, now that inspections are so thorough, the women and the children who used to try and get across with false declarations of citizenship, with false papers, hidden in vehicles, are now opting to take the desert route. So we have seen an unprecedented increase in the number of women and children that are dying in the desert. If you want to seal the entire border, be my guest. But what you cannot do as an alternative is channel migrants to their death. Mexicans and people from other Latin American countries account for a fraction of the apprehensions at the Mexican border. I sat down today and added up all the nationalities and found out that only 1,600 of almost 1 million apprehensions corresponded to people who were not from this hemisphere or from the Caribbean, and that's less than 1/10%. Most of the rest are Chinese. Of the people that are not from this hemisphere or the Caribbean. Granted, there are a few hundred people apprehended from countries that are on our terrorist list who also try and get through the southwest border. But the Canadian border would seem to be of much greater concern. People claiming refugee status can enter with little scrutiny and can stay almost indefinitely. There are about 9,000 agents on the 2,000-mile U.S.-Mexico border, and there are 1,000 agents on the 5,500-mile border with Canada. As they say, go figure. The INS was absorbed by the Homeland Security Department this March. It seems to have emboldened the agents, at least in the San Diego sector, which extends up to San Juan Capistrano. This summer, the agents, their union, dismissed as so much failed legacy from the INS a memo by their own sector chief directing them to concentrate on the immediate border area. The memo was issued following neighborhood sweeps that were getting rasher by the day. The agents were waiting outside Catholic churches to detain people after Mass. They were patrolling around schools when parents were picking children up, and they were maintaining stakeouts in front of centers that dispense food benefits for pregnant women and children. What good purpose is served by denying iron-fortified milk to U.S. citizen babies born of undocumented mothers? I can't understand. Will our Homeland Security be enhanced? Hardly. The agents even literally skulked, around the corner of the Mexican consulate, despite our obligation not to obstruct the access of foreign nationals to their country's representatives. It is not, however, just a question of stopping and interrogating people who are illegally here whenever and wherever they are found. The larger problem is that the agents are acting as though they have a license to stop and interrogate whomever they choose, civil rights be damned, as though there were no Fourth Amendment limitations to border enforcement. The agents are supposed to have a particularized suspicion based on objectively observable factors that the person they stop is in the country illegally. And that does not mean that someone looks Mexican. As the courts have pointed out, a shared physical characteristic has little or no probative value in a place where a substantial part of the population is Latino. 1/3 of the population is Latino in San Diego County. In this sector, however, ethnic appearance without any furtive behavior increasingly passes for reasonable suspicion. When I try and cross the border, one of the last times that I tried to cross the border, I was I was put through a little quiz of state capitals, which absolutely terrified me because I never remember if Bismarck is the capital of North Dakota or South Dakota. But nevertheless, a Border Patrol agent has told me that, probably somewhat flippantly, that I met the profile of somebody that could be stopped along the street. So if that is so, I guess it's fair game for anyone with Latino appearance in this sector. It does not bode well that Commissioner Bonner countenanced insubordination by his agents who defied their chief's directives, saying that it would keep them from doing their job, the job that they were sworn to do, as though they were the arbiters of their own authority. An ethnic profile is bound to get more pervasive. If the Attorney General has his way, state and local law enforcement agencies will be on the lookout for those who are unlawfully in the country, the bulk of whom look Mexican. The police are at this point precluded from enforcing, the police are at this point not precluded from enforcing the criminal provisions of the Immigration and Naturalization Act, or to hold those violating state criminal laws for short periods of time until they can be turned over to federal immigration officers. But the Ashcroft Justice Department maintains that the states and local law enforcement agencies also have an inherent power to stop and inquire about immigration status and detain people merely for civil violations of federal immigration law, mere presence, something that has been prescribed by the courts on federal preemption grounds. The position of the Clinton administration was that such authority must be formally delegated as provided by Section 133 of the Illegal Immigration Reform and Immigrant Responsibility Act of 1996, which imposed a number of constraints, including that the designated officers receive adequate training regarding the enforcement of relevant federal immigration law. There was substantial opposition to the Ashcroft proposal from police chiefs themselves, who complained that it would set back several years community-based policing geared towards the typically tight-knit immigrant communities. Distrust of local law enforcement, it was argued, fostered an environment in which victims would be afraid to report crime and witnesses, not to mention tipsters, potential tipsters, would be afraid to talk to the police. By virtue of the 10th Amendment, states' rights, Ashcroft cannot command local law enforcement to take on the task, a task that is essentially federal. So he proposed that police voluntarily conduct immigration status checks in the course of encounters, whatever that is. This year, the Ashcroft proposal has undergone a transmutation. It's called the CLEAR Act, which is before Congress, has a number of sponsors, and which would discontinue federal funds provided for the incarceration of illegal aliens if states and localities fail to authorize their police forces to enforce immigration law. The monies are not insubstantial. Nationwide, 665 local and state governments shared $805 million over the past 2 years. Ominously, the CLEAR Act would make local law enforcement immune from personal liability as long as the officers were acting within the scope of their duties for enforcing immigration law. Most hypocritically, given that the pull factor is employment, and we keep people desperate for work go where the work is, and we keep giving them work. The CLEAR Act criminalizes unlawful presence, and it would subject those who are in the country illegally to fines, imprisonment, and asset forfeitures. This goes well beyond an anti-terrorism mission. It is about the cyclical backlash against so-called illegal aliens in times of economic downturn.
The first thing I want to address is the matter of closed immigration hearings pursuant to what's called the CREPI Directive or the CREPI Memo. CREPI is C-R-E-P-P-Y. It's not creepy. The memo was issued by the Chief Immigration Judge, Michael CREPI, on September 21st, 2001, and it was an order to close certain proceedings to the press and the public and to include family members and friends in that closure. These were cases deemed special cases because of the events of 9/11. One case received particularly intense attention, and it's the Detroit Free Press versus Ashcroft case in the Sixth Circuit. The Detroit Free Press challenged the closure of the case of Rabib Haddad, who was subject to removal for having overstayed a tourist visa. The government suspected that the charity Haddad operates supplies funds to terrorist organizations. His family, members of the public, including Congressman John Conyers, and several newspapers sought to attend his deportation hearing. Without prior notice to the public To Haddad, to his attorney, or anyone else, the courtroom security officers announced that the hearing was closed to the public and the press. He was denied bail and remained in government detention. So the Detroit Free Press challenged this, seeking an injunction against blanket disclosure of removal proceedings as unconstitutional. And they prevailed in the federal courts, and this decision was affirmed on appeal by the Sixth Circuit Court of Appeals. Writing for that court, Judge Damon J. Keith writes, "While the Bill of Rights zealously protects citizens from laws, it has never protected non-citizens facing deportation in the same way. In our democracy, based on checks and balances, neither the Bill of Rights nor the judiciary can second-guess the government's choices." Here he's referring to the choice to exercise removal against an individual. Quote, "The only safeguard on this extraordinary government power is the public, deputizing the press as its guardians of liberty. Today, the executive branch seeks to take this safeguard away from the public by placing its actions beyond public scrutiny. Against non-citizens, it seeks the power to secretly deport a class if it unilaterally calls them special interest cases. The executive branch seeks to uproot people's lives outside the public eye and behind a closed door. Democracies die behind closed doors. We affirm the district court's order granting plaintiffs a preliminary injunction." Now, I can't tell you about that case without also telling you about a case from the Third Circuit where a New Jersey court ruled on the same arguments in the opposite way. But that case went on appeal to the Supreme Court, and the Supreme Court denied certiorari, so they will not hear that case. In the Sixth Circuit case, which is very favorable in terms of its civil liberties ruling and language, the government has decided not to appeal, and it has reported that it is reviewing its policy and position on closed hearings. The next topic I want to talk about is the detentions themselves and access to public information about them, particularly with reference to the concern for adequate legal representation. The leading case on this topic is the Center for National Security Studies versus the U.S. Department of Justice case that comes out of the D.C. Circuit Court of Appeals. The case concerns an initial FOIA request submitted by the Center to the Department of Justice about those persons detained pursuant to the 9/11 investigation. The Department of Justice denied that request, and the Center went to federal court, where it asked for a variety of different types of information relating to the names of people who were detained, whether or not they had counsel, the names of counsel, what detention facilities were used, and various pieces of information. And they got some pieces in a favorable ruling, but not everything that they asked for. The case then went on appeal, where the D.C. Circuit reversed and wrote, "We conclude that the government was entitled to withhold under FOIA an exemption, the names of INS detainees and those detained as material witnesses in the course of post-September 11th terrorism investigation. The dates and the locations of arrest, detention, and release of all detainees, including those charged with federal crimes, and the names of counsel for the detainees." That case involved the names and circumstances of about 1,200 persons who were interviewed after September 11th, about 700 of whom were detained on INS charges. As of June 2003, 74 remained in detention. Many have been deported from that group. It also involves a second group of about 134 individuals who were detained for federal criminal charges, 99 of whom were found guilty either through pleas or by trial. And then there's a third category of persons held under the special material witness warrants, and that total number is unknown. Sealed orders prohibit the government from releasing any information about those proceedings. The third topic I want to discuss in this 9/11 investigation theme is the designation of enemy combatant. This designation is used by the President in his capacity as Commander-in-Chief, and it may result in an individual being transferred to the custody of the Department of Defense, detained in a military facility for the duration of hostilities, and held without access to judicial review of the basic determination of enemy combatant status. 3 uses of enemy combatant designation have been contested in federal court. 2 involve United States citizens. The third, a foreign national of Qatari who entered the United States on a valid visa. The first is Yasser Hamdi, a U.S. citizen who was captured in late 2001 in Afghanistan. His pleading suggests that he was seized in an active combat zone in the theater of war. Hamdi was transferred to Guantanamo Bay and subsequently to a military brig in South Carolina. His representative, with broad support from law professors and civil rights organizations and various legal foundations, has sought judicial review of the designation and the lawfulness of his detention. The petition called for a hearing requiring the executive branch to substantiate its contentions that Hamdi is an enemy combatant with more than its declaration, which a Fourth Circuit panel concedes to be incomplete and reliant on hearsay. However, the Fourth Circuit has ruled that Hamdi remains in custody according to time-honored laws and customs of war. In a strongly worded dissent, Circuit Court Judge Diana Motz concludes, in contrast to the rest of her colleagues, quote, "Even in the darkest days of World War II, after the devastating attack on Pearl Harbor, the Supreme Court recognized a greater role for the courts in safeguarding individual liberties than the panel now provides to Hamdi. Implicit in the term national defense is the notion of defending those values and ideals which set the nation apart," end quote. It's a very different climate today. It reminds us more, I think, of Japanese internment. Within 6 months of the December 7, 1941 attack on Pearl Harbor, the executive branch had ordered the detention of more than 120,000 persons of Japanese ancestry in the United States, 70,000 of whom were citizens by virtue of birth. The internment began at designated centers and continued with the relocation of individuals to particular camps. In San Diego, it was Civilian Exclusion Order Number 4, issued on April 1st, 1942, that mandated all Japanese, aliens, and U.S. citizens alike living south of the San Dieguito River to be excluded from the West Coast Military Zone by the following Wednesday, April 8th. One member from each house was instructed to report to a control station between the 2nd and 3rd. Sounds like special registration to me. And on April 7th, more than 1,100 San Diegans of Japanese ancestry left by train for Santa Anita, a racetrack in Los Angeles, and from there to the camps. I think that the numbers are probably not comparable, but what is comparable about Japanese internment is the exercise of executive authority and the legal arguments that underscore detention then and detention now. What the Washington Post had to say then was, quote, "The outright deprivation of civil rights which we have visited upon these helpless and, for the most part, no doubt, innocent people may leave an ugly blot upon the pages of our history." So I open up the historical question for our discussion. But before I turn to questions, I want to end on an idea that I think is enormously important, and it's the observation of law professor Alexander Bickel, that the Constitution speaks in terms of people most of the time, citizens rarely, and never of the two interchangeably. Not only are the immigrant and the terrorist conceptually and radically different categories, but each, along with the citizen, the alien, the man, the woman, the child, and so forth, is, in the first instance, a person endowed with rights. And I think that restoring that idea to our public consciousness would serve us very well. So thank you. Thank you.